Despite claims by Canada's finance minister, Canadian citizens are directly impacted by FATCA, the Foreign Account Tax Compliance Act, an American law about to be imposed on Canadian citizens resident in Canada, with the blessing of our own federal government. On Canada Day, July 1st, our nation will begin to surrender its sovereignty and citizens to the United States as FATCA becomes reality. Sound incredible? Here are some exchanges from the House of Commons Finance Committee.
Of the Standing Committee on Finance, orders of the day pursuant to the order of reference of Tuesday, April the 8th, 2014, study of Bill C-31, an act to implement certain provisions of the budget tabled in Parliament on February the 11th, 2014, and other measures.
I come before you as the voice of 1 million Canadians. We are Canadians. Many have been Canadian citizens for life or for decades. We chose Canada. We expect Canada to now choose us and our rights over foreign bully demands.
This is a life-altering, monumental event.
How many Canadians do you estimate will be affected by this? Are you even aware of the number?
No, I'm not aware of the number, but it's not going to be very many.
Really? 1 million?
I've never heard the term American person before. You're either an American citizen or you're not American citizen.
I mean, I think it's ridiculous to call these people U.S. citizens. These are Canadian citizens, residents.
We were offended and insulted to hear Minister of State for Finance call us American citizens abiding in Canada.
But in terms of trying to improve it and offer amendments, a suggestion was made to delineate out who was caught up in this net, because we have agreed that we are not a tax haven. I don't think we're any threat to become a tax haven. I think any suggestions is just foolish by the American or Canadian perception. But that to delineate who is actually being targeted and not allow Washington to do all of that designation. Should we seek out amendments to delineate more specifically under our powers as legislators who it is that will actually be impacted and affected by this intergovernmental agreement?
I think the determination of who is impacted is already a done deal. That's a decision that was made by the U.S. That's under U.S. tax law. Unfortunately, the U.S. taxes it taxes U.S. citizens based on citizenship, not on residence.
But we had the minister here earlier, and on 3 occasions he said Canadians will not be impacted by this agreement. On 3 occasions. Is that a fair thing to say? Is a dual citizen a Canadian?
I would argue they are, yes.
Okay.
It is absolutely essential under any FATCA agreement that the definition of U.S. Citizen could never include any Canadian citizen who's resident in Canada.
Look, this IGA gets Canadian banks off the hook from reporting. It does not get Canadian citizens who happen to be considered American persons off the hook.
To be frank, FATCA frightens people.
This is really a gotcha penalty regime the Americans are imposing on these unfortunate roughly 1 million Canadians.
Canada generally does not and should not furnish information to foreign countries on Canadian citizens living in Canada. But FATCA, as reflected in the bill before us today, tells us to ferret out our own citizens as likely U.S. tax debtors and present them and their financial resources to our most important treaty partner in an agreement of dubious status that may not even be a tax treaty.
And I do have some questions, and I want to start with Mr. Berg, if I may. The U.S. government is flipping over the sofa cushions looking for every dime, aren't they?
It seems that they are doing that.
Yeah, and that's really the purpose behind FATCA.
It is an information grab, I would say.
What we can do is decide what we as a government are willing to do with respect to our citizens.
Yes, but here's what, thank you. What everyone's generally saying is this is terrible, but you have to do something, and so this is something. That most of the banking institutions say, we hate this law, but we need something in its place. And in the absence of something, I guess this will do.
Yes, you have this law. You also have the law which is called the Revenue Rule, which says Canada will not lend assistance to any other country in their tax rules. And constructively, that must mean that we do not hand people over, put them in a pen, put a spotlight on them, and show the U.S. where they are and say, come and get them.
They and 1 million other Canadians were betrayed by the FATCA intergovernmental agreement.
The U.S. tax code is hostile to anything foreign, and that would include anything in Canada in general.
FATCA is really a sea change in this cross-border tax information relationship. Under our current regime, it focuses on temporary residence in each country. Here we have a focus by the United States on permanent residents in Canada. Of course, U.S. citizens, dual citizens, joint account holders with U.S. persons, and so on. The second real change is the type of information we're thinking about sending across the border. The Americans want us to hand over account information, including deposits and withdrawals. Under current Canadian domestic law, banks do not provide that to the CRA. So this is very personal information, very sensitive information that Canada has never shared with any foreign country previously.
FATCA may, and we have seen elsewhere, impact the ability of U.S. citizens in Canada to access proper financial services.
I think if you were to ask the Canadian government and Canadian financial institutions, they would obviously prefer that FATCA did not exist.
So the deal is a bad deal for Canada in light of this unique relationship.
But the reality is you can negotiate a better IGA given our relationship with the Americans.
We either could have or still can do a better job at protecting Canadian interests. We're a democracy, a sovereign country.
The committee is likely going to be aware of rather jingoistic, hyperbolic rhetoric admonishing finance for ceding Canadian power, ceding sovereignty, and also encouraging Canada to stand up to FATCA.
In 2011, and many times after that, Finance Minister, the late Jim Flaherty, said, FATCA has far-reaching extraterritorial implications. It would turn Canadian banks into extensions of the IRS and would raise significant privacy concerns for Canadians. Terry Campbell, president of Canadian Bankers Association in 2012, called FATCA the poster child for the problem of extraterritoriality. It threatens to erode Canadian sovereignty.
I just want to make one clarification comment to Ms. Swanson. I, in fact, am the one who made the statement on the U.S. Congress has spoken. I freely admit that. And when I said that in the context, when we were in Washington, we were pressing the Treasury Department on this whole FATCA thing. And the response we got back from the U.S. Treasury person was, well, I'm sorry, Mr. Allen, but Congress has spoken. So we were somewhat mortified by her attitude as well. So I just want to say that that was the context of that comment. So.
Okay, what we would like is we would like Finance Canada to go back to U.S. Treasury and say Parliament has spoken.
As the committee hears such comments, we encourage it to remember that FATCA is U.S. law.
Under threat of economic sanctions and penalties, Canada surrendered its sovereignty to foreign power with the IGA. Why do our most heinous criminals have more charter rights than I do? Asked the Nova Scotia police officer of 33 years.
The Revenue Rule says that Canada won't lend assistance to the U.S. to collect U.S. debts of people who were Canadian citizens when the debts arose. Period, full stop, no qualifications.
Financial information under PIPEDA is considered, along with health information, to be the most sensitive form of personal information. Banks must keep this confidential under all circumstances. The IGA overrides that. That's just one example. It also overrides the Privacy Act, the Access to Basic Banking Services Act, and many others.
Right.
All information sharing activities must be undertaken in a way which respects privacy obligations. These obligations include limiting the amount of personal information collected to only that which is necessary for the stated purposes and safeguarding it appropriately.
So I wanted to know what your position is to the constitutionality or non-constitutionality of the bill.
There are privacy concerns raised and discrimination concerns raised. I'd like to just state, though, that remember that we do not have an anti-discrimination provision in the IGA.
If Canada mandated financial institutions to seek Canadians born in China, India, Iran, or Eritrea for CRA to transmit private financial information to those nations, there would be outrage. Canadians born in the United States should have the same rights as all other Canadians. Canada should strongly defend those rights and not sacrifice them to a foreign country.
The Privacy Act has been declared to be quasi-constitutional by the courts.
If the intergovernmental agreement or the provisions of Bill C-31 are in conflict with the Privacy Act would prevail.
That would be my view, certainly.
Okay. You've also expressed concerns about the constitutionality of these provisions. I wonder if you could elaborate a little bit for us.
Thank you for the question. Yes, I would agree with those constitutional law experts who suggest that the IGA violates the Charter. This is a very dangerous precedent.
The most frightening question for these people today is, are you or have you ever been a U.S. citizen?
We have an awful lot of amendments pertaining to this clause, so I suspect there'll be quite a debate on this.
I'd like the members across to carefully consider the serious issues that have been raised at this committee concerning the implementation of this deeply flawed agreement. I hope they'll carefully consider and support our NDP amendments that address some of the serious problems that have arisen. It's become increasingly clear through departmental and witness appearances at this committee that the Conservative government simply has failed to adequately study the implications of FATCA and the implementation agreement with respect to privacy, constitutionality, and cost. Surely that's of concern to every member of this committee, and it's more important, we say, to fix this and protect those many Canadians that are going to be affected than it is to ram this through in an omnibus budget bill that this agreement has no place being in the first place. So the first amendment, Mr. Chair, is NDP 6, which simply would say in Clause 99 that it be amended by adding, after line 11 on page 73, the following. Despite any other provision of this Act or the agreement, for all purposes related to the implementation of this Act and the agreement, the term U.S. person and the term specified U.S. person does not include any person who is a Canadian citizen within the meaning of the Citizenship Act or permanent resident within the meaning of the Immigration and Refugee Protection Act, and who is ordinarily resident in Canada. This amendment is intended to address one of the most central issues pertaining to FATCA, and perhaps its greatest flaw, that this will impact Canadian citizens who are deemed to be U.S. persons and targeted by this agreement, but who are, in every other way, our fellow Canadian citizens and permanent residents of this country. We should not create a second class of Canadians with a second set of rights just because American law deems them to be U.S. persons.
Of course, what the honourable member is asking us to do is change really how the Americans apply their own laws, which they have a right to do. We don't have to agree with it, but they tax based on citizenship, and that's simply how it is. It is clear, Mr. Chairman, that the scope of persons in respect of which the U.S. seeks information under the IGA, consistent with the U.S. FATCA legislation, includes all U.S. citizens, including those who are dual citizens or residents of another country. This is based on the requirements of the U.S. tax system, as I mentioned earlier, which places tax filing obligations on all U.S. citizens, even those that are also citizens of another country.
But Canada is a sovereign country. Canada has rights at international law. Canada has chosen, through this agreement and this Budget Implementation Act, to treat some of our fellow Canadians, even those who are born here of U.S. persons, as second-class citizens. And that, of course, is going to be the thrust of a charter challenge which is being prepared right now. And so I just want to put that on the record, Mr. Keddy, it's not just dual citizens. We're talking about people who are married to U.S. persons. We're talking about people born here of U.S. persons, and they are now different than other fellow Canadians. And so the purpose of the amendment is just to say that we are all the same in Canada, and that our government ought not to have sacrificed our sovereignty just because of a U.S.-based, citizen-based taxation regime.
We have to be very cautious about looking at any amendments to this, and I look at this amendment as being one that potentially would invalidate the IGA and the U.S.'s mind. So,
Liberal Amendment 3 ensures that simply that Canadian law will take precedence over this agreement with the United States regarding FATCA, and not the other way around.
Why the government wouldn't vote to clarify that the Charter of Rights, the Bill of Rights, the Human Rights Act, the Privacy Act, Official Languages Act, and the access to information will supersede anything we sign in this tax treaty is beyond me. If it's redundant, then so be it. Let's have a redundant piece of aspect of a legislative bill. I'm stunned that something so obvious can't be accepted into law. The government of Canada is so likely to end up in court under this part of the tax treaty that they're signing with the U.S. and is going to then cost the Canadian taxpayer so many millions of dollars and untold number of Canadians the financial grief of going through this. It's just this predictable problem that the government's creating for itself.
This is really fundamental. We know that this bill, if passed as it is going to go to the Supreme Court. And we know from the best constitutional legal brain in this country, Professor Peter Hogg, whom, by the way, the late Jim Flaherty said gave him an A in constitutional law. So we have that last anecdote from Jim. He agrees, that Peter Hogg is the constitutional expert in Canada. And he says very clearly, this act contravenes Section 15 of the Charter. I don't know why we're pushing it through in an omnibus budget bill when it will clearly fail at the Supreme Court.
I will take the vote then on NDP 6. Okay. All in favor of NDP? You want a recorded vote on NDP 6?
Mr. Allen?
No.
Mr. Keddy?
No.
Mr. Saxton?
No.
Mr. Van Kesteren?
No.
Ms. Truppy?
No.
Monsieur Caron?
Oui.
Monsieur Cullen?
Oui.
Mr. Rankin?
Yes.
Mr. Shaw?
Yes.
Okay, that amendment is defeated.
If our Canadian government won't stand up for Canadian citizens resident in Canada, then Canadians need to stand up to the government. Please help. Invest in a free and sovereign Canada. Donate to our Legal Challenge Fund today.